The American tort system is nothing to be proud of. As Lawrence McQuillan, Director of Business and Economic Studies at the Pacific Research Institute, recently concluded, America's tort system imposes a total cost on the U.S. economy of $865 billion per year. This constitutes an annual tort tax of $9,827 on a family of four. It is equivalent to the total annual output of all 6 New England states, or the yearly sales of the entire U.S. restaurant industry. These costs hurt domestic American jobs and businesses, and much of these costs are imposed on the American wholesalers and distributors. In the United States, any seller of a product, not just the original manufacturer, is liable for damages caused by a defective product under the legal doctrine of strict tort liability. The fact that a wholesaler or distributor did not create the defect, or did not participate in the design or production of the product, or did not author the product instructions or warnings, is no defense under current law. This often results in great unfairness, and efforts to aggravate that unfairness would simply increase the unjustified costs already imposed on American companies. Normally, a wholesaler distributor in the U.S. Or in a U.S. product liability suit will bring the manufacturer of the defective product into the case as a defendant, if the plaintiff has not already done so, and claim indemnity from the manufacturer as the faulty party. However, this may not always be successful, especially when the product is made by a foreign supplier. If the foreign supplier does not have a legal presence in the United States, such as a U.S. subsidiary of a U.S. plant or other offices, or is not agreed by contract to be subject to the jurisdiction of the U.S. courts, the wholesale distributor often cannot obtain jurisdiction over the foreign supplier in America. The wholesale distributor may still claim indemnity from the foreign supplier, but it will have to do so in a distant overseas court system that may not yield a reliable result or compensation. One prime impediment American courts face when seeking to assert jurisdiction over foreign corporations is the Constitution itself, which cannot be amended through simple legislation. Under the Due Process Clause, it is, as interpreted by the Supreme Court, a foreign corporation that has its principal place of business overseas, engages in little or no economic activity inside the United States, and does not otherwise subject itself to the jurisdiction of the United States, cannot be subject to the jurisdiction of the various state courts. These problems for domestic distributors have been brought to the fore by a recent spate of problems with defective products whose defects may be traced to Chinese or other foreign sources. Tort reform advocates such as Victor Schwartz, who is a witness before us today, have proposed that Congress consider requiring that substantial suppliers be required to post a bond or appoint an agent for service of process before they can enter into transactions in which their component parts are distributed in the U.S. Such proposals could help ensure that money from foreign manufacturers is available to compensate those injured by foreign component parts in the U.S. and also allows such foreign companies to be subject to the service of process in the United States so American courts can assert jurisdiction over them. Unfortunately, however, legislative proposals that have been introduced to address this issue have tended to focus on misguided attempts to amend the rules governing the Consumer Product Safety Commission in a way that threatens more litigation, but less actual enforcement of product safety issues. As the Wall Street Journal editorialized just last week, just in time for toy season, Congress is promoting new legislation to crack down on companies selling products said to be defective or dangerous. A Senate bill would empower all 50 state attorneys general to effectively run their own consumer product safety adjuncts, deciding what constitutes a safety defect and making their own judgments about appropriate remedies. The result could be a jigsaw system of conflicting standards across the country. You can see where this is going. Banned in Michigan, toys being smuggled across the border into Indiana, and so on. And without a consistent national standard, small businesses would be particularly hard hit, lacking resources to monitor the evolving rules nationwide. All of this happening at a time when the appetite for business self-policing is strong. Businesses have every incentive to clean up their acts given the costly damage to their brand equity from news stories about tainted toys. I look forward to hearing from all of our witnesses today, but I hope we can all agree on at least one thing at the outset of this debate, and that is that no attempt to amend the tort liability system in America should increase the burdens of current the out-of-control lawsuit industry already imposes on American jobs and businesses, especially small businesses. Thank you, Madam Chair, and I yield back.